back to my channel. So today I'm going to resume the second part of Cmpa website Good Practice Privacy and Confidentiality. If you haven't checked my part 1 for this video, I would highly recommend you to go and check it out. So I read about the introduction, we talk about some of the circle of care, implied concern, express concern, and more importantly sharing information with the families. Now I'm moving forward with the leaving informations on the voicemail. So what we talk about here is, once you are working in a clinic, you are working in a hospital, sometimes you need to contact the patients by phone. Patients are not with you, but you have their information, you have their phone numbers, you need to talk to them, and you try to contact them and patient doesn't receive your phone, or they miss the call, then the voicemail comes. What you need to share on the voicemail: as voicemail is often shared among family members or others, it is advisable to regularly confirm with the patients their preferred mode of communication. Even if the patients agree to voicemail communication, it is prudent to leave a little information as possible. Why we talk about it? Because you never know, when you are trying to share some of the information on the voicemail, who is going to listen, either the patient, either someone else. So as I mentioned in my previous video about the STVBI testing, so this one same goes here. You are a family doctor, you ask your patient to come in, and patient did the STVBI testing, they came positive, you wanted to share the results, and you call the patient voicemail came up, and you share some information, and unfortunately that was heard by the partner, not the patient. That's going to be a big trouble, because patient did not wanted this information to be revealed to the partner, and that's reasonable. So that's why don't do it. Don't try to give any kinds of reports, any kinds of reasoning why you are calling. Just say that I'm trying to call, I need you to call us back at this number as soon as possible, or as your own convenience, or something like that. Generally, appointment scheduling will be appropriate, but avoid leaving any sensitive information on voicemail unless the patient has given instruction to do so, a fact which should be documented in the medical record. Overall, the correct answer is don't leave anything. So what do you want to say? You'll say, hi, my name is Dr. XYZ. I'm calling from office. Can you please give me a call back at this number? You don't even have to tell to whom you're talking about and which patient is it. It's really up to you, as little as information possible. Or even you can just say, we were trying to call you, can you please give a call back? And if they don't call back, that's still fine. You can call sometime later, or maybe after a few days. So that's the one thing you can do it. But don't try to put more information in that, and that makes a trouble, because you never know about the voicemails. Office staff obligations. As an employer, you are mercilessly responsible for the actions of your staff. It is important to have a clear confidential policy that outlines the staff expectations for protections of personal health information. When orienting staff, review your office confidentiality and privacy policy and ask each staff member to sign a confidentiality agreement that highlights the importance of these issues. It is wise to repeat the signatures of confidentiality agreements yearly as a continual reminder of its importance. Educate staff not to discuss patients' information, particularly outside the office. Remind staff to take care that they are not overheard by the patients in the waiting room when they are speaking on the phone. Arrange the office to reduce the likelihood of this happening. Similar, remind office not to divulge patient's information to the family members or the third party without the patient's consent. So what this overall says, it's basically a scenario. You are a family doctor, you are working in a clinic, you have your own staff. That means your reception, the nursing staff, or maybe someone who's taking care of the equipment part, and the manager and someone. You need to tell them, even though they are not doctors, they are not healthcare providers before, you have to tell them whatever you hear from the patients, whatever you hear or see on the computer in the patient's information, you are not going to share with anybody else. Not outside the office, not to the people who is not actually the patient itself. Number one thing. Number two things, sometimes the arrangement looks like in a way, this is the reception, this is the waiting room. If someone is talking on the reception about some of the patients, maybe talking to a colleague, maybe asking them, oh, we saw this report, this comes positive, do you see that? Did you check that? Or did you ask the patient? Like, you just generally talk, but someone else heard it, which is not good. That's why they are saying either you make your arrangements in a way that the waiting area is peoples are not listening what the staff is saying, or they should not do it if that's not the case. So if you have a clinical assistant and the clinical assistant want to talk to one of the patients on phone because they have the virtual appointments, they should not be using that reception staff phone. They might be using some rooms where they can lock the room and talk to the patient the same way as an inpatient can be followed. So this kind of a thing is very important because you are not only obligated to protect the information, but your staff is also, because you are the employer, you are hiring them, and it's your responsibility that they take care of their part. And definitely signing an agreement is also a good way to reminding them. Health information's custodians and agents. This is one of the things which is sometimes quite confusing. What is custodian and what are the agents? So let's talk about it, and I will give you an example at the end if it comes in my mind. A patient's personal health information belong to the patient, but the paper or the electronic medical record belongs to the physician or the institute or the clinic. A health information custodian refers to the person or the organization who has the custody or control of the personal health information contained in the medical record. So, what we are saying is personal health information, the whole health information is patients. Patients, it belongs to patients, but the custody is for us, the physicians who take care of this, the hospital where the EMR is there, the clinic, if you are working in a clinic where five other doctors are working, so that clinic manager is the custodian of the health information. This includes health or care organizations such as hospital, pharmacy, laboratory, as well as some individual physicians such as owner of the clinic, physicians working as a sole practice in their own practice. The custodian is mandated to protect personal health information and to put in place system and procedure to prevent the unauthorized access. When we are working in a hospital, we have a central EMR system. The hospital management has the responsibility to take care of that by doing an unauthorized access prevention, by doing the cybersecurity stuff to make sure that, because they are custodian, they are having that information in their database and they need to protect it. As a result, many institutes run random and direct chart access audit that can identify who accessed what record, when, and for how long. So this is the one thing, like whenever you do any kind of EMR, in my understanding, all the EMRs does record which information was accessed at what time by which person, because when you log in, wherever you are clicking, everything comes in the record, and if something happens, they can come back to you because they have the all the previous data, they have the audits. So you can imagine a hospital of 600-700 staff members, they have the record of each and every one with their names, so they don't have to go by department, by floor, by timing. They just have to look who was the person who was getting the information. That's why whenever you come out of the computer, especially the public computers, that means the hospital, make sure you log out because you never know, someone else is coming and using your account. An agent is a person. An agent is a person who is authorized by the custodian to perform certain activities on its behalf regarding personal health information. Generally, include this this includes a physician practicing in hospital, certain medical clinic, as well as administrative staff in the medical clinic or hospital. Custodians are the ultimate responsible for personal health information as well as the action of their agent. So there are two different things. First is, if a doctor is working in their own clinic and they have 3 staff members, then the doctor is the custodian and these 3 staff members are the agent, while all have the same responsibility. But if you work in a hospital, then the management is the custodian and the doctors are the agents. Even though there is a difference in the names, but the responsibilities are always the same. So that's the one thing which we talk about, the health information between the custodian and the agents. It's not about patients, even though the personal health information belongs to patients, but these two words belongs to something else. Accessing information for educational purposes. Definitely research purposes and educational purposes is very common and we access it. Many physicians will seek to understand the outcome of their treatment decisions in order to learn from their experiences and may wish to present anonymized patient's case at rounds. This long held transitions of learning from experience nevertheless required access to the patient's health information. As agents within the hospital, like physician, resident, medical student, should check with their custodian in an hospital that it is generally the medical record department or the privacy officer to determine if they permit access to personal health information for the educational purposes. I think everybody is aware about it. When you're presenting a case round or we are trying to do some teaching, be the 68 years old male come with the complaint of chest pain and had a shortness of breath, what could be the differential diagnosis, what are the things we were looking for. So basically there was a real patient there, but you did not tell the name of the patient, you did not tell the date of birth of the patient, but you still steal or you still borrow the age, the gender, the symptoms of the patient. So that's why if you are working in a teaching hospital, it is very common. But if you're not working in a teaching hospital, you need to make sure that you are aware about the privacy rules and regulations. Third party request for information. This is mostly about research. Physicians have the professional obligation to provide report to the third party. I'm sorry, it's not about research, it's mostly about the people who are not physicians and who are not doctors. One of the very common thing is insurance, private insurance company. They do ask a couple of things. When you are doing a life insurance, they give you the form. The patient will come, oh, this is my life insurance. They're asking me to some medical questions. Can you please answer that part? So that's we call the third party. Physicians have the professional obligations to provide report to the third party as requested by their patients. When requests for notes are made informally at the time of the visit, handing the notes to the patient allow them to know the content and to control its distributions. It is wise to document this and put a copy of the note in the record. What they're trying to say is, let's suppose patient comes to you and say, oh, one of my third party, maybe my office, maybe my insurance, maybe someone I'm trying to apply for, let's suppose they are trying to apply for some sports activity, are requesting some of the information, then it is your professional obligations. Professional obligations means because you know their history and you are the authorized person who can provide this information. So when they're requesting, you need to make the notes. Then you need to tell, like, let's suppose when request for the notes are made informally at the time of visit, whatever you are trying to make it, make sure you are handling the patients those notes, allowing them, they should know, okay, should I, these are the contents, these are the things in your past medical history, and you have the control to distribute it, you have the control to tell me what should I say, what should I not say. You cannot lie, you cannot do something inversely or reverse, but you can say the things which patients want to tell you. It is a wise to document this, and it is important that you document it. Okay, patient came with the document of getting a driver's license fitness form, but patient did not want it to talk about their STI because that does not matter to the driver's license, right? So then you did not say that. Express concerns, usually in writing, should be obtained for personal health information sent directly from doctor to the third party, like insurance company and employer. Sometimes it happens like the company sends you directly to the fax and they say, oh doctor, can you send us back? Don't involve the patients, but you need to take the express concern from the patients because you don't know if that's really patient is aware about it or no. The request should indicate what information is requested, and you have to say, okay, this is the form I got from your third party. Do you want me to tell them information about you? What information the patient is authorizing the custodian to release? That's what I was talking about. If patient doesn't want to tell something, you need to document it, and you don't have to tell it because they are having the authority to whom to not to share and to share. If the information is very sensitive and the patient is not aware of the content of their medical record, it is wise to confirm the patient's understanding the information in the record and to seek the directions about what information they wish to divulge. So this is the one thing, like sometimes patients say, oh, it does not matter, you can tell everything. You want to know if this is the one thing should I tell. Like the insurance company will be like, okay, this is suspicious, maybe that can made a barrier for the patients in the future. You don't know, you have to make a decision on the basis with the patient's understanding. If the patient doesn't understand, if they don't understand, you have to direct them, you have to tell them. So that's the one thing which we are talking, because this is the third party. Third party means the people who are outside the circle of care, who are not the family members. Someone is asking something and you need to know if the patient is okay to send the information. You cannot send the information until patient is not okay. Interacting with the police, but you cannot lie. If patients say, oh doctor, I have a diabetes, don't write down diabetes. No, you cannot do that. You cannot make that as a non-diabetic person. Interacting with the police, this is also one of the common thing, especially in hospitals. Police may sometimes accompany patient in care settings like the emergency department, while the physicians may be naturally inclined to cooperate with the authorities. Patients' personal health information should not be released to the police without the patient's express consent or as required by the law, such as when the physician receives a court orders, search warrant, or such as a result of statutory duty to report. Police is coming and saying, "Oh, tell us about the alcohol level of this patient because he was drinking and driving." You are not supposed to tell until unless police come with the court orders, police come with the search warrant, or police give you some kind of a duty to report statutory results or something, or patients give you the express consent. A search warrant guarantees the police board legal authority to search and seize the evidence and information. Police should disclose only the personal health information listed in the warrant. They cannot ask about other stuff. In hospital, the responsibility for releasing information lies with the hospital, typically the medical record department, as the custodian of the information, not the individual physicians. So if in hospital an emergency drunken drive case came in, there was an accident happened, police came with the legal documents like the court orders or something, the custodian, the managing department has to work on that. Physician is not liable to do. Sometimes it's just the responsibility of the custodian. So this is all about the part 2. I'm going to discuss all of these parts in different videos. You can keep checking my channel. Some of them are pretty short, but it seems like it's a lot in a one video, so I will try my best to maybe divide into two to three videos. And I hope you like my content. If you have any special request, please let me know. Thank you so much and have a great day.